So today we are continuing the theme of copyright exceptions for research. So last week we had Peter Yazzie addressing the more general elements of fair use, and we've just been describing that as an open, general, flexible exception. Open in the sense that fair use is open to all uses by all users of all works for any purpose. But we haven't started getting into the topic that we're doing today, which is the specific uses of that exception by the courts to help clarify the bounds of text and data mining as a permissible fair use. And that will be the topic of Michael Carroll, who will go first. And then also there's a regional directive that requires all EU countries to adopt a specific form of text and data mining. And so that's the topic that Felix Reda will address second. So let me give just quick introductions. Michael Carroll works here. He's a professor of law. He's faculty director of PIJIP at American University. But one of his specific recent papers that we're reading today is on the text and data mining as a type of fair use. Professor Carroll is also a founding member of Creative Commons, serves on the board of the Public Library of Science, and he previously served on the National Research Council's board on research data and information. So with that introduction, Mike, let me turn it over to you.
Great, thank you, and greetings to everyone. It's a delight to be part of this series. The whole basis of copyright law was based on a pre-internet form of publishing and dissemination. And there are many ways in which the premises of copyright need adjusting. And this talk about creating space in copyright law for using technology for text and data mining research is part of that. I've also been focused on access to scientific and scholarly research through the open access movement, because the idea is that now that you can publish almost for free on the internet, why are we restricting access to the fundamental sort of advances in scientific knowledge? And the United States government recently has adopted a policy that will require all federally funded research to be made available online. But the way that that research will be made available will make it difficult for text and data mining researchers to use it. We have to remember that copyright law covers uses of information. So it's a use restriction. And I'm going to talk about fair use as a limit on those use restrictions. But even when you have a right to use, you still need to access, and you need to access in a usable format. And when it comes to TDM research, we see that even if you accept the argument I'm about to present about fair use, you will still have to grapple with the fact that scientific publishers who don't want to share their data, essentially their research articles, or don't want to share them in a format that is in an XML structured format that is easy for text and data mining researchers to use, that that access control can provide leverage over the terms of how text and data mining research gets conducted. So for those who are activists, for those who are advocates for actually making text and data mining a reality for researchers, you need to focus both on legal controls over access as well as legal controls over use. Now, with that said, let's get into a discussion of fair use and text and data mining. So I'm briefly going to talk a little bit about why we care about text and data mining. And in my advocacy for open access, since going back to 2004, there have been a number of reasons why open access is an important policy objective, including equity in access to information. But in addition, it is the ability to conduct text and data mining. That's been a part of the open access argument from the beginning. I also want to make another big point. Professor Yazzie talked about fair use as a flexible provision that is formally designated as a limitation on the author's rights under copyright in the US. But I want to make the claim that because behind that limitation on copyright is the affirmative right of free speech in the United States, that effectively fair use produces a user's right. If fair use says it's not an infringement of copyright, then using a copyrighted work becomes protected free speech. And I think it's important to conceptualize users' rights generally as positive rights for users, because in the discourse that Felix will talk about, when the discourse around copyright is focused on limitations and exceptions, you get much more limited outcomes in terms of use rights. Then I will talk a little bit about how, in addition to fair use, there are some definitional elements to what copyright covers that can potentially be used depending on how text and data mining is conducted. So the way to think about this is, first, if a text and data mining researcher needs to make copies to produce their research, and those copies are of copyrighted material, do those copies necessarily count for copyright purposes? And because of the specific way we define what counts as a reproduction in US copyright law, I have an argument that some TDM copies may not even count as reproductions for copyright purposes, and therefore we don't even have to talk about fair use if the TDM researcher structures their technological use of the data in a particular way. But many researchers will want to make, permanent or long-term copies of their underlying data that they're doing research on, and those would be copies that count, in which case fair use would need to step in to justify the making and use of those copies. And so I want to make a claim that using copies of copyrighted work in the ways that TDM researchers need to is a fair use, and I'll explain that. So I think there are going to be two claims I'm going to make about fair use and what it permits that will be in contrast to what we're going to hear from Felix about what happens in Europe. One is that I think fair use permits both commercial and non-commercial TDM research, because the core question in copyright law in US is the research making a quote unquote transformative use? And if it is, whether the research is commercial or non-commercial becomes significantly less important. In addition, I don't think that there is a requirement of quote unquote good faith to qualify for fair use, which means even if the research is being conducted on a copy of the material that was unlawfully obtained, the use may still qualify as a fair use. And this is, in the TDM research context, this is particularly important since there is a website called Sci-Hub that has gathered copies of tens of millions of scientific research articles. I will admit right off the bat that Sci-Hub is an infringing website. It is infringing copyright in the US. We have judgments from US copyright law that says, so I'm not arguing that Sci-Hub creating its hub qualifies for fair use under US copyright law. I am arguing, however, that a TDM researcher could access Sci-Hub and perform a TDM research sort of algorithm or task, and that use of the Sci-Hub corpus would still count as a fair use. And that's a controversial claim, but I will try to defend it as best I can. All right, so from the beginning, why do we care about TDM research? Because the power of digital technology used on an individual machine, and even more importantly, through a digital network, is far beyond what the human mind can possibly do. And so we can use these tools to advance the cause of the progress of science in health and medical fields, in a variety of research fields, by better understanding what is already known. There's far too much literature published for any individual researcher to possibly have time to read it all. So if you can computationally, quote unquote, read it to find patterns in what has been already published, that strengthens the understanding of a researcher to see where's the next thing that we need to explore. And it can aid curiosity-driven research by both finding sort of specific research opportunities, but potentially opening up entirely new research fields that would be invisible to a human researcher because the patterns in the data cannot be detected other than through large-scale computational processing. So just one example that, for researchers trying to find a cure to Alzheimer's, there is a hub in which well over 100,000 papers are gathered, and no individual researcher could possibly process all that without the aid of a machine. In the article that I've published, I select this sort of DARPA's big machine process. So DARPA is the Defense Advanced Research Projects Administration. I believe that's what the P is. It's a part of the US Department of Defense that is supposed to be doing cutting edge research and using public funding to do the kinds of research that no private R&D funder would ever spend money on. And DARPA funding was what gave us the basis of the internet. So it shouldn't be surprising then that DARPA is focused on using the internet for its publicly beneficial uses. So this graph shows you a little bit about sort of what a TDM process might be, that you take these published articles, you turn them into text that a machine can read, you run them through a model or a machine just sort of at a shallow level because you haven't created a data model around how to interpret this. You can then start to form that model and revise it. You then assemble the data, revise the model, run it through the model, and now you have a model that does more than just say, for instance, how many times does X term show up in these articles, and start to say, can you, the algorithm, show me what relationships you think exist between the presence of, say, this protein and the manifestation of this particular kind of cancer. So it's really letting the machine make some algorithmic predictions that can then lead researchers to test whether they think that's true. These journal articles are all subject to copyright law. And the incorporation, this looks like a technological function, and it is, but from copyright law's perspective, this is copying. And each of these steps involves making copies of copyrighted works. Who said you can do that? Well, I argue fair use in the United States says you can do that. But in order to really understand the argument, I want to first say, what is fair use? Formally, the way copyright law is structured in the US, the copyright owner is given a bundle of exclusive rights that are defined quite broadly, such as the right to reproduce the copyrighted work in copies. And then that is followed by a sequence of specific exceptions and limitations to those exclusive rights. And so the way those limitations are written is, it is not an infringement of copyright if you do X, Y, or Z. Fair use is the broadest of those. It says it is not an infringement of copyright if, and then you're given 4 factors to balance to determine whether a use is fair use. You look first at the purpose and character of the use, i.e., why are you using someone else's work? You look at the nature of the work. How much authorship is actually being used? How much of the information in the copied works are actually factual information or things that don't have an author? Then you look at the amount and substantiality. How much are you using? And these 2 inquiries, the first and third, are very tightly connected. Why are you using it? And are you using an appropriate amount for your purpose? And then the last is sort of focusing on the economic effects of the use on the copyright owner. So you look at the effect of the use on the potential market or value of the copyrighted work. And so this is why I sort of frame the question for TDM research is, first we have to ask, are these copies that count? And then if they are, is this use happening in a market that matters for copyright law's perspective? Now, in terms of my justification for why copyright or fair use is a user's right rather than simply a privilege of the user, I've basically given you the algorithm. If free speech is a user's right, and if fair use protects the user's free speech, therefore fair use is a user's right. So that's my argument. It's been accepted by the Supreme Court in Canada, who has explicitly talked about their fair dealing provision as a user's right. I think you can transpose that understanding directly to the fair use limit for the same reasons. Now, I'll go through this fairly quickly because in some ways, this is legally relevant to the extent that a researcher wants to essentially stream the data from an article into their algorithm, such that from a technological perspective, you would never actually make a copy of the article. Instead, what you would do is create a buffer that would take a data stream. You can turn a PDF into a data stream. And if the analysis would take place as that data stream flows through the buffer, but you never make a permanent copy, my argument is you haven't even made a copy. And this is specific to US law because the reproduction right says the exclusive right is to reproduce the work in quote unquote copies. Copies are defined in US law as a copy that can be first perceived, reproduced, or otherwise communicated for a period of more than transitory duration. And in this very strange case that no one would have predicted happened, copyright owners sued Cablevision, which was a cable TV company that was creating a remote digital video recorder. And because of specifics we don't need to get into, the only legal question on copying that the court had to consider was whether the buffer copies that Cablevision was making that lasted 1.2 seconds were copies that count. And the court said, no, that's a transitory duration. So I'm relying on that case for the proposition that if you are simply streaming data through a buffer, you are not actually exercising the copyright owner's right to make copies. It's an odd case, but that's what we have, and we have it on the book. So I just want to make sure that anyone who's working on this always makes sure the first question is, do I even need to care about copyright? Or is the activity covered by copyright? This is my example of how you might stream the data from Sci-Hub. And if you're streaming that data through a buffer, I would argue under US law, you're not even making a copy. We don't even have to talk about fair use. One other point, and this is for the international audience, just because I think the United States representatives have been a little bit cagey about what they've done with free trade agreements and other agreements. US has pushed our trading partners to adopt restrictions on quote unquote temporary copies in bilateral free trade agreements. So for example, in the US-Korea free trade agreement, it says, that both parties will prohibit all reproductions, including temporary productions. However, we've met with the United States trade representatives and we said, wait, are you arguing that you're creating a new legal obligation to have US law cover even temporary copies? And they say, oh, no, we are quote unquote coloring within the lines. We're honoring that, Cablevision case. So even though there are these legal obligations to regulate temporary copies like that, the US understanding of what counts as temporary is longer than the 1.2 seconds that has been deemed to be not covered by copyright. And as a result, there are, even under these free trade agreements, there are some copies that don't count. And Korea and other trading partners who have to regulate temporary copies don't have to regulate the transitory copies. But there are many other temporary copies that would stay on your screen for long enough that they would be regulable both under US law and under these free trade agreements, and then of course all other copies. So I'm just arguing that to the extent that trading partners think they have an obligation to alter their law to cover even copies that stream through a buffer, I think that argument is off point. All right, let's talk about fair use. So there are three cases where the analysis will change, and I'm going to focus on TDM research on scientific journal articles. The analysis may apply to other sorts of analysis, but I want to be careful. There's some problematic forms of TDM research that I would want to see get a different analysis. So for instance, if you think about Clearview AI, a company that is vacuumed up massive amounts of facial images from social media and then created a sort of facial recognition technology used by law enforcement. It may be that the making of all those copies count as a fair use under copyright law. And so in the absence of privacy law, you have nothing to complain about. But I wouldn't reach that conclusion based on my analysis. I would want to do a different analysis on a TDM application like Clearview. I'm talking about more like the conventional TDM research on research as the focus of my talk. Now, when that research incorporates expression, so the outputs basically have quotes from the articles and that sort of thing, then that's a different fair use analysis. And then what I'm talking about, though, is the outputs that analyze what's going on in the copyrighted text, but does not use that copyrighted text in the output. Now, I think you can keep a complete data set of all the articles for reproducibility uses. So for example, I'm doing research. One of the ways my research should be validated is if some other researcher can get the same results. So I need to keep my data set so that they can test whether my output is actually scientifically valid. So I think that's an important use of the corpus that should be deemed to be part of the fair use analysis. And I've got a bunch of technology-specific fair use cases in the US that justify this. So when image search engines make copies and create thumbnail images of images, and the courts have said that's a fair use. Turnitin involved a plagiarism detection software that made copies of student papers, held them in a corpus that could then be searched for plagiarism, again, a fair use. Google Books copied the full text of more than 15 million books in order to create a search function for those books, again, a fair use. And then more recently in the Google versus Oracle case, we get our United States Supreme Court reaffirming the importance of transformative use as the basis for holding these kinds of uses. Making copies to produce a useful other use is a fair use. And that's what we get in terms of what I think the law is. Now, the last thing to worry about is US law also has a really strong commitment to contracts and freedom of contract. And the courts have held that if you have a fair use right, but you enter into a contract that says, well, I'm giving up that fair use right, we will enforce that contract. So in the TDM context, a number of academic libraries are entering into quote unquote licensing agreements with publishers in order to give their patrons access to the articles. And many of those access agreements limit the ability to engage in TDM research as a contractual matter. So even if I'm right that you have a legal right to engage in the research, if you give up that legal right in a contract, we will enforce that contract. And so I think that's a problem for the academic library community to help solve, is to really resist publishers' demands that you give up your fair use rights in exchange for access to the data. Now, there are publishers that will argue that TDM research is not even a transformative use and therefore does not qualify for fair use. I think that's wrong. Their argument is, well, I'm offering a license for that use, so by definition, it can't be a fair use. And that's not what the courts say. The courts say if the purpose and character of the use is transformative, that is, using it for this productive social purpose, then even if the owner of the copyright is offering a license, we should not treat that license as consequential, because fair use protects transformative uses, in my view, as a user's right, and we can disregard from a copyright law perspective the existence of those licenses. That said, though, the contract point makes those licenses powerful. So it's really about using the access right rather than the use rights of copyright that give those licenses some purchase. So that's the end of the slideshow. Let me just show you these licenses and look at the conceptions of how text and data mining research are conceived of in two different parts of the scientific publishing industry. So Elsevier is the largest scientific publisher in the world. Elsevier has started to create some open access titles that would publish under a Creative Commons license that would give you very broad use rights. So basically, Elsevier has divided itself into two worlds, an open access publishing world and a subscription world. With respect to the subscription content, you have to click through and make an agreement, and that agreement will give you the bespoke API, that is the formatted access to the data, to the articles. But look at all the restrictions. You get it for your institution. You're allowed to distribute the outputs of your text mining as long as you live by these different limits. If the images are part of the output, that you have to have clear rights for reuse. And look at what they want you to tell you is that this is what their view of your rights are as a user, that you can only make non-commercial use, and it limits these various sorts of use. And then as a variety of things that you're not allowed to do. And my argument is these are all things that you can do under fair use. But since Elsevier is a global company and fair use is a US-based users' rights, it's possible that if you're in a country that does not have a flexible limitation and exception on copyright, that these actually are legally binding restrictions. In that case, there is a different vision, which is open access publishing. So as Sean mentioned, I recently finished my service on the board of directors of the Public Library of Science, which is one of the first movers in the open access publishing world. And you can see this in completely different approach to how text and data mining is conceived in the open access publishing world, right? The right to read is the right to mine. All of these benefits come from this. And so open access publisher like PLOS not only tells you legally that you can do whatever you want with it, but creates a data set in XML format called all of PLOS, where you just click this link and you can download 4.5 gigabytes of research articles, all formatted in XML. So you can start running your research on the data right away without having to reformat, without having to worry about Elsevier type licensing. So we're really in this world of scientific discovery and research that is divided between an open access vision of scientific research, where you get immediate access to the text, that you should have the right to create derivative works and all the creative things that the technology allows a researcher to do, and the older legacy subscription restrictive model that requires pay to play for anyone who wants access to the content. And even when Elsevier gives you access that they're not making you specifically pay for, they still want to have legal control over what the researcher can and can't do, which is a very different vision of how the internet can be used for research. And you can see that I have strong sympathies towards both having users use their legal rights under fair use in the United States, and also to encourage publishers to move to an open access publishing model that cures both the access problem and the use problem. With that, I'll stop talking. I thank everyone for their attention. You can see, I hope, and you can hear in my voice the passion with which I am committed to this issue, because there are patients with cancer out there. There are people who will benefit from this research if we unlock the potential of this technology and the creativity of these researchers to do what they can and will do, if we just get the law in line with the public benefit that flows from text and data mining research. Thank you so much.